Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the Chit Fund Amendment Bill 2018. The bill seeks to make the presence of two subscribers mandatory during the declaration of results. To discuss the issue, I have with me Mr. T.S. Sivaramakrishnan, General Secretary, All India Association of Chit Funds, and Mr. Sumair Khanna, Advocate. Before we begin the discussion, let's see what all is there in the bill. The Chit Fund Amendment Bill 2018 leaves open the minimum contribution limit, which was earlier 100 rupees, in order to increase the application of the law. Under a chit fund, people agree to pay a certain amount from time to time into a fund. Periodically, one of the subscriber is chosen by drawing a chit to receive the prize amount from the fund. Various stakeholders in the chit fund business have expressed concerns regarding operation of the chit fund business. Based on these concerns, the central government constituted a key advisory group on chit funds to review the existing legal, regulatory and institutional framework for chit funds. The advisory body suggested legal and regulatory initiatives required for orderly growth of the said sector. The recommendations included improvements in the institutional and legal structure to allow growth in the chit business and reduce regulatory burden, and at the same time protect the interest of the subscribers of the chits.
See, the major challenge for the chit fund industry is that of the unregistered sector. So, to bring in investor protection measures and transparency, registration is a must. While speaking on this Chit Fund Act, the formulation of the act is that of the center, whereas implementation is by the respective state. So, it's very important that all the chit transactions are duly approved by the respective state government.
According to the Chit Funds Amendment Bill 2018, now the fraternity fund will also be covered under the proposed bill. This was earlier not included under the existing law. Fraternity fund is also like a chit fund but specific to a social group or brotherhood. The proposed bill seeks to make the presence of two subscribers mandatory during the process of declaring the results. In case the presence of the subscriber is through video conferencing, it has to be recorded by the foreman in the minutes of the meeting and signed by the subscribers within 2 days. The bill raises the foreman's commission ceiling from 5% to 7%. Foreman is responsible for managing the chit fund. The proposed law also empowers the foreman to have a right to lien for the dues from subscribers to discourage default. The bill removes the limit of rupees 100 and allows the state governments to specify the base amount over which the provisions will apply.
Some part has been amended just to make it more transparency, just to make it more relevant, because as far as the section 85 is concerned, the minimum subscription amount was 100 rupees, right? That has been amended because due to that amount, now the bill, existing bill seems to be irrelevant, because in 1982 the value of 100 rupees was quite different. Now in 2018 the value of 100 rupees is quite different in respect of 1982. So, to make this act relevant as on today, this amendment has been brought and section 85 has been changed.
The Parliamentary Standing Committee on Finance, in its report on efficacy of regulation of collective investment schemes, CIS, and Chit, had also recommended to finalize the legislative and administrative proposals for strengthening and streamlining of the registered chit fund sector. The committee had also recommended the need to quickly firm up the legal framework for the chit fund sector. The bill seeks to amend the Chit Funds Act 1982. The 1982 Act regulates chit funds and prohibits a fund from being created without the prior sanction of the state government. The Chit Fund Amendment Bill 2018 was introduced in Lok Sabha on March 12, 2018 by Finance Minister Arun Jaitley. With Nishtha Malhotra, Amritanshu Rai, Rajya Sabha TV. So there are two parts to the entire chit fund business. One is the registered and the other is the unregistered, the ones who do not register. So the registered ones are accountable and are under the ambit of this bill and under this law. But the unregistered ones are where the concerns are. So what's the growth of the registered vis-a-vis the unregistered? How big is the unregistered chit fund business and how big is the registered chit fund business?
There was a recent study under the aegis of the Bill and Melinda Gates Foundation. They spent almost 4.5 crores for the entire study. If the outcome of the research is an indication, the volume of the unregistered sector is almost 100 times that of the registered sector.
So the registered sector, the rough amount of money that we've been able to get out is about 5,000 crores. So are you saying it is nearly 50,000?
The volume of the registered operation as per the last statistics available all over India per annum is almost 45,000 crore.
Oh, so and the unregistered goes?
If it is 100 times, it's a mind-boggling figure, but it's a fact. See, the system has come to live, whether public, whether the government like it or not. The method on which the chit fund operation committee or BC, whatever you call, the money is being made available. There are several factors, I don't want to elaborate it now. The system has come to live. So the purpose of the bill is, as anybody could see, is to come up with a smart regulation rather than a hard regulation to make sure that the investor protection measures are brought in.
So do you think the unregistered after this bill will be forced to comply and come under the ambit of this law?
Well, see, there are very useful suggestions as it was read out earlier. 5 amendment has already come. I was myself a member in the key
advisory group. Will that help
group.
in bringing in the unregistered
to
sector?
Some extent, yes, but not to the extent the industry expect.
So that's where I think the bill lacks. Sir, you wanted to add to that?
This is where the entire story goes.
Yeah.
It is the mushrooming of unregistered sector which causes the defaults, and the registered sector which already has a lot of preventive mechanisms and accountability and regulatory framework working on it, gets the blame for the entire unregulated sector's defaults. So every time an unregulated sector's person defaults on payments and flies away with the public's money, the entire sector gets the blame for it. And what loses out on that is the regulated sector, because for the public at large, it is a chit fund. Without recognizing, it's like a number of investment schemes were floated in the name of Green Valley and all those. But then when the regulatory framework came in and SEBI as a regulator acted upon them, all of them were shut and a number of people's money was stuck. So this is where the unregulated sector, without being checked upon, is allowing the people to, in a way, put a question mark on even on the regulated sector.
So I just want to understand the bill as it has been defined and the act that exists. What all does it cover? So the new addition is the fraternity. Now, what does that really imply? What is the meaning of that? What all comes under that ambit, that definition?
See, the entire thing as to changing the name to fraternity. Initially, now what is planned is that the name is being changed to fraternity. So far as fraternity, the changing of name is concerned, it will hardly, to my understanding, change the nature of scope of business. It's more of distinguishing it from the normal or the what the normal public thinks as a chit fund, which is because of the overwhelming presence of unregulated chit funds. So it will distinguish it in certain ways by changing the name.
What, according to your understanding, is the fraternity fund? Is it the fund that the families or social grouping or brotherhoods or such people contribute?
To certain extent, yes.
What all does it include,
to certain extent,
sir?
yes.
If you can add
See,
to
the
that.
perception on chit fund, it is terribly bad, especially for the media. Anything under the sun fail is called a chit fund failure. So the major failure is that of the unregistered sector and the Ponzi scheme and multi-level marketing scheme. They are all banned under the Banning Act, the Price Chit Money Circulation Banning Act. Since the chit fund is there in the Banning Act as well, often people are get misguided that any chit fund fail is that of the registered sector. Since we are failed, see, industry, I mean, associations functioning for almost 40 years. We have failed in educating the media and increasing the financial literacy. So we thought we will change ourselves by changing the name, identifying ourselves as a fraternity fund. That is how the fraternity fund came in.
Okay, so that's how the name.
If you can't change others, at least you can change yourself.
So there was a stigma attached to the word chit fund.
Exactly, chit fund.
Okay, going to the, so there was also several, you were part of the several advisory groups that made recommendations to the government. There were several recommendations that were not included, although the process has been happening for the last 7 years. So what are these recommendations that you think should have, could have been included and would have really helped in increasing the growth of the entire chit fund sector?
When in 2011, the Key Advisory Group was formed by the Department of Financial Services, which is under the arm of Finance Ministry. It constituted Reserve Bank of India, Indian Bank Association, all Chamber of Commerce, the entire registrar of chit funds throughout the length and breadth of the country, Amarchand Mangaldas, Juris Corp, Ernst & Young. There were several discussions. They came up with, there were criticism for and against. The first question that I myself asked was, do you really need the chit fund scheme at all? Has it outlived its purpose? But the answer came that no, the reach to the last one man, in the, especially in the lower and middle income household, and the services being offered by this indigenous financial institution has its own role and cannot be substituted by any other formal banking or other intermediaries. Then came the recommendations. The idea was to position is as best suitable to the requirement of the middle and lower income households. So one of the few major recommendations which came out was number one, the reduction in the security deposit to be given under section 20 for the proper conduct of the chit.
What is it at the moment?
It is 100%.
And what was the recommendation, sir?
Recommendation, just since there are other enough measures, there is minimum capital requirement, there are other financial adequacy norms, punishment clauses are enough. And this particular section is much more, it's not there even for the normal NBFCs. So since it is over regulatory in nature, and all the more when they wanted to remove it entirely, it was decided to reduce the 100% to 50%. That provision is entirely missing in this.
What was the argument that was given to you for not including this?
No, there is no argument at all. That's why we are very disappointed. I am the voice of the industry. We are thoroughly disappointed the fact that one of the major recommendations from the Key Advisory Group has not come through in the proposed bill.
Proposed bill. You would like to add to that, sir?
So far as already there seems to be a justification that from 100% it should have been decreased, only because yes, there are already a number of ways in which the investors' money in the regulated chit funds is protected, including the ones which Mr. Krishna has already highlighted. But to my mind, it seems that even though it is not incorporated, the bill is still in its gestation period. So, with the
you are saying that there are chances that it will be incorporated sometime or the other, because the process is still on.
Process is still on.
So, summing up the whole thing, 2 points, 2 major points that was made out. The unregistered sector, the unregistered chit funds are bigger in volume compared to the registered ones who are really regulated and take most of the blame for the things going not right or going wrong in the unregulated sector. So much so that the chit fund name itself has acquired some sort of a stigma. So that is why the sector industry on their own changed the name to fraternity fund, which now has also been included and incorporated in this bill. It's time for us to head into a break. When we come back, we will tell you about the existing laws regulating chit funds. Welcome back. The Chit Fund Law 1982 was enacted to provide for the regulation of chit funds, which are indigenous businesses and have conventionally satisfied the financial needs of the low-income households. There are around 30,000 registered units. While the number of companies has not increased, the value has increased to a huge amount, as Sir said, nearly 45,000 crore rupees. The law was notified by the central government in 1982 in different states on different dates. If the law has already been implemented in a particular state, its own law would have to go. State governments have the power to implement certain rules to exempt chit funds from the provision of the law. Last year, the central government notified the chit fund law in Arunachal Pradesh, Gujarat, Haryana, Kerala and Nagaland.
As per this new model bill, state governments will have to frame the rules, they will have to appoint the competent authority, and accordingly RBI may also intervene, because few days back ED has taken action against such companies, and presently 5,000 companies are there which are registered as per the chit fund companies, and it in the rural areas and in the town areas, chit fund companies are operating in much larger manner, and many cases are there in the Supreme Court. So new law will certainly help the people to get the justice.
Under the chit funds law, all chit fund companies need to be registered with respective state governments. The regulator of chit funds is the registrar of chits appointed by state governments. Power of adjudication of complaint lies with the registrar. The state government is the appellate authority in the matter. In case of failure of a chit fund business, the responsibility for winding up such a business also rests with the state government. The risks involved in chit fund business are the misuse of the pooled funds by the manager, when members stop paying the dues and have already taken the first bid, and also when the discount rate is rigged and a desperate member ends up paying a higher discount.
The major advantage of the Chit Fund Act is utility or appropriation of the subscribers' money is fully curtailed. That's very, very important. We should not be allowed to take deposit or utilize the public funds. But at the same time, the kind of database that we have, some freedom to undertake fee-based activity is very, very important. That suggestion also has not come up through in this present bill. And there again, I am duty bound to tell you, there are so many other external factors which are very important for the growth of the chit fund industry. Like with all the 1995 sections in the Act, I am sorry, the preventive provisions are very, very minimal. To explain it further, some insurance facilities available is needed rather to protect the public money in our hands. All the punishment provisions, see, I can be hanged in the nearest available tree if something is going wrong, but that will be too late for a subscribing public. What the public requires is, if 100 rupees is deposited with me, that should be insured.
The Prize Chits and Money Circulation Schemes Banning Act 1978 defines and prohibits any legal chit fund schemes. Again, the responsibility for enforcing the provisions of this law lies with the state government. Some of the words commonly used for chit fund are chit, chitty or kuri and fraternity funds. In all such kinds of dealings, the mechanism combines credit and saving in a scheme, in which a group of individuals come together for a predetermined duration and subscribe a certain sum of money by way of periodical installments, and each such subscriber in his turn, as determined by lot or by auction or by any other specified manner, gets the collected sum. In this way, people who are in need of funds and those who want to save are able to meet their requirements simultaneously. With Nishtha Malhotra, Amritanshu Rai, Rajya Sabha TV. There is no provision of insurance in the entire chit fund business. This is required to protect the interest of the subscribers in case something goes wrong with the entire business. And that is what we need to take forward. Why do you think, despite the recommendation of the association, there is no provision for including the insurance backup for the entire business?
This seems to be also quite even I can't understand as to why, because when in every sector even for a flight you get yourself insured. Here is investors' money, and if an investor can get it insured, I don't think there is any it could lead to any other consequence but protecting the investment of the investor, which is the final purpose of the act itself. So insurance per se of the person's hard-earned money, which is sought to be protected even otherwise, seems to be a genuine reason for it.
Right.
There can't be any excuse for
not including
Not
it or not
including.
having it. Do you really need a provision to really push in the insurance aspect in your sector? Why can't the chit fund entities themselves, you have your own chit fund entity, well, is there a problem if you try and enforce the insurance without a provision being made in the laws?
See,
What is the
ultimately,
problem?
you require the permission from Insurance Regulatory Authority and connected agencies. And all these things can be done only with the hand-holding approach from the government. Of my own, I cannot come up with an insurance company, I cannot even get the license. If you look at there are people who are willing to insurance us. If there were, as you call, actuaries who do the study. Some study was done by the association. Total amount of failure was determined. The cost of amount involved, the cost of servicing, the profit, everything was made out, and the insurance premium was coming very, very reasonably low.
How low is it in percentage form?
See, if you look at, to put it in a simple word, if there can't be insurance for robbery and burglary, we are not worse than a robber. At least we have an address and we still, and it was not even 0.25%.
0.25% of the corpus.
So we can bear the cost ourselves if it comes to that. But ultimately we need support from the government, that's very important. Otherwise all these legislations are only on the books.
Right.
If number of legislation is indication for our development, India should be the most developed country, which unfortunately we are not.
Okay, I get the point, Mr. Sivaramakrishnan. Fee-based activity was something that you people wanted to have in the system. What does it actually mean, and how is it going to really help the entire sector?
See, we are in business because we want to earn profit. And profit, you will agree, is not a bad word. My own company is almost 73-year-old. We work for profit, and the kind of data bank that we are sitting on is a gold mine. The Chit Fund Act rightly now prevents any other business. As said earlier, it prevents misutilization or misappropriations. So what has happened now? Whatever profit we earn, that is siphoned away for some other business. The bottom of the pyramid, the growth of the chit fund company, that doesn't grow. If that has to happen, we should be allowed, if not other, okay, we don't want to accept deposit because that will be subject to the risk. At least fee-based activity can be given so that that money is not misused or misappropriated, but we can earn some revenue.
Right. So that is
very reasonable. I think it appeals to anybody.
You want to add to that?
See, the entire thing is, otherwise the chit fund, the registered chit funds are already regulated in a very systematic manner.
Correct.
The problem is the unregistered and unregulated sector, which also calls itself chit fund, and that is where now they are changing their terminology to
Fraternity fund. So my point is, yes, the foreman is the person who's managing the entire chit fund is normally the target of all these laws, and that seems to be very well regulated in the earlier law and this also. But what about the defaulting subscribers? Is there any way that the bill actually provides some sort of empowerment to ensure the defaults do not happen, because that's very crucial for the entire sector?
The problem with this financial sector is most of the laws deal with them as a financial problem only, not as also as a criminal problem or as a penal section. The problem comes, yes, there is a provision in the law as to lien being there with the foreman on the funds of the subscriber. But what happens if the subscriber, it's a high value chit, and the subscriber takes away one chit and defaults? Where does the lien, on what lien does the foreman rely upon? Except for the normal securities which he may have taken at the time of giving the chit.
The amendment actually empowers the foreman in this to actually follow up and ensure defaults do not happen. So that right has been given to the foreman.
All those rights are of civil nature. There is no penal provision because of one person's default, 100 suffer.
Oh.
The entire chain, the entire ladder collapses because one step in the ladder
Subscriber defaults.
So there is no penal provision against the defaulting subscriber. There should be one, so that the defaulter also is scared of defaulting. So if the foreman should be scared of flying off with the subscriber's money, the subscriber should also be equally responsible and diligent towards the entire community. See, it's a ecosystem.
Yeah, it's a ecosystem.
It's a ecosystem.
Correct. So the members pool in, one person takes the chit, then next month all pool in again, someone else takes the chit. I understand. So the default part, how do you think can it be fixed?
See, the legal system, see, there is failure is everywhere. I mean, it's a part of, everything failing, including the government. So there are enough improvement in the legal system as well. For example, if you file a recovery under the section 138, he'll be able to explain it better. It takes years, even as on today, to get the money back.
Is it because of the judicial delays?
Delay, exactly.
Because civil nature, so there is a process that needs to be followed.
As you rightly say, the subscribers are equally responsible for the proper conduct of the entire group. So there is one useful provision in the Act is, there is a provision for arbitration. We need not go to the regular court of law for getting a decree. But when it comes to recovery, it has to be again filed in the regular court. So we get stuck. It takes 3 years, 4 years, 5 years. So people do not have the capacity to hold on. The system tries to shake.
So summing up the whole thing, two broad points that have come in. I mean, insurance provision is the requirement of the sector, and also somewhere the other, the defaulting subscribers also need to be discouraged, and in an effective way. Thank you, Mr. Sivaramakrishnan and Sumair Khanna. That's all we have time for. Thank you for joining us on this discussion. It's time for us to end the show. You can watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.